Welcome to this explainer. Today, we're diving deep into a strategic analysis of India's 2025 labor codes. We are looking at a massive, literally ground-up legislative overhaul that's going to reshape the livelihoods of hundreds of millions of people. I mean, we're talking about redefining one of the absolute largest workforces on the entire planet. Let's get into it. Now, imagine trying to run a modern, hyper-connected digital economy, but you're forced to use a rulebook that was largely written before the internet even existed. Sounds like a nightmare, right? Well, that is exactly the situation India has been facing. Picture the sheer chaos of trying to protect today's gig workers, the folks driving for ride apps or delivering food, or trying to scale modern tech-driven industries, all while tangled up in this outdated, pre-independence era regulatory net. The friction between these new-age business models and old-world laws has been causing immense economic drag. So, take a look at this number, 29. That represents the massive, tangled web of separate, overlapping labor laws that previously burdened businesses. It was like a giant puzzle with pieces that didn't fit. For MSMEs, those micro, small, and medium enterprises, navigating this maze of multiple licenses, registrations, and returns wasn't just a minor headache. It was a severe barrier to growth. And on the flip side, huge numbers of informal workers were just slipping through the cracks, left entirely unprotected by this chaotic system. Okay, let's dive into this roadmap for mastering this complex policy system. We'll start with the old system's flaws, then break down the 4 pillars of reform, look at balancing business and welfare, examine the critical gaps, and finally wrap up with a mastery review. Starting with part 1, the old system's flaws and exactly why reform was needed. The bigger picture here is an evolutionary leap. We are shifting from a high-compliance regulatory nightmare of 29 disparate laws into a streamlined 4-lane system set to roll out in late 2025. This isn't just administrative cleanup, you know? It's a strategic move to boost global competitiveness. Because think about it. When major economies like Singapore modernize their rules to attract investment, India absolutely has to make similar systemic leaps to ensure its industries can grow, create jobs, and formally integrate the workforce. Moving right along to part 2, the 4 pillars of reform, the what and the how. This framework actually rationalizes compliance into 4 distinct codes. First up, the Code of Wages. This mandates a statutory floor wage, meaning states cannot set minimum wages below a centrally defined living standard. Second, the Industrial Relations Code formally recognizes fixed-term employment, which grants those workers equal benefits to permanent staff. Third, the Code on Social Security introduces time-bound EPF resolutions and expands state insurance nationwide. And finally, the Occupational Safety and Health Code. This one mandates safer working conditions, caps work hours at 8 per day, and explicitly guarantees double pay for overtime. It's a total game changer. Now, what's really interesting about this is how the changing nature of work finally forced lawmakers to adapt. For the very first time, terms like aggregator, gig worker, and platform worker are legally defined. This is a monumental shift. It means the law finally recognizes the millions of flexible service-based roles created by modern technology. And because of that recognition, crucial Social Security coverage can now be extended to an entirely new class of the unorganized workforce. That brings us to part 3, balancing business and welfare, and looking at the core impact. Okay, so on one side of the scale, we have some incredible employer benefits. We're seeing a massive shift from policing to facilitation. They're actually replacing traditional inspectors with inspector-cum-facilitators and swapping out imprisonment with monetary fines for first-time offenses. Plus, businesses get single registrations and digital compliance. But on the exact same scale, we have massive worker wins. We're talking a universal minimum wage across both organized and unorganized sectors, the mandatory issuance of appointment letters to formalize jobs, and an unprecedented nationwide expansion of health and life benefits. Now, the hidden challenge and opportunity here is the number 300. Under the old rules, establishments with 100 or more workers needed prior government approval for layoffs, retrenchment, or closure. Well, the Industrial Relations Code bumps that limit up to 300. To put that into perspective, this gives mid-sized companies crucial operational flexibility. They can scale up and adjust to market demands without bureaucratic paralysis. Though to be totally fair, critics actively argue that this inherently reduces job security for the workers in those specific firms. So, how do we fund these new welfare measures for the modern economy? Well, aggregators, think of your major ride-hailing and food delivery apps, must now funnel between 1% and 2% of their annual turnover into a dedicated Social Security fund. Now, this is capped at 5% of the amount paid to workers, but it represents a brilliant structural mechanism. It actually secures life, health, disability, and old age benefits for unorganized workers who previously had absolutely no safety net whatsoever. Moving on to Part 4, critical gaps and challenges, or essentially the limitations of these new codes. The critical bottleneck here is the concurrent list problem. In India's constitution, labor sits on the concurrent list, which means both the central and state governments can frame rules. So while the center has passed the codes, states still have to draft their own specific rules for implementation. The result? By mid-2025, we are looking at an uneven patchwork of protections. For instance, a worker in Karnataka might end up with totally different regulatory safeguards and timelines than a worker in Assam. You can imagine how that complicates reality for businesses operating nationally. Then there is the severe backlash from labor organizations. Under the new Industrial Relations Code, a 75% approval requirement has been established just for a strike to be legally recognized. In 2024, trade unions held nationwide protests in major cities like Delhi, Lucknow, and Kolkata, explicitly labeling this provision as, quote, anti-labor. Their main argument is that achieving a 75% consensus in massive firms makes collective bargaining nearly impossible, basically weakening the workers' negotiation power right from the start. Beyond the protests, some major systemic hurdles remain. There's a distinct risk of excessive government delegation, where key definitions are just left to notifications, bypassing parliamentary oversight entirely. Then there are these broad exemptions allowing the bypass of safety rules in the rather vague name of public interest. Furthermore, there's a real risk that employers might just overuse fixed-term employment contracts simply to avoid granting permanent status to workers. And, crucially, there is a massive awareness gap. While over 30 core workers are registered on the government's e-Shram portal, many remain totally uninformed of their rights. On the business side, less than half of small firms actually understand their new compliance requirements. Let's move to and see how this builds our mastery of the topic with Part 5, the mastery review and takeaways. Let's consolidate everything we've covered. Here are the critical visual memory anchors you need to retain. 1. The consolidation of 29 fragmented laws into 4 streamlined codes. 2. The historic legal definition and inclusion of gig and platform workers. 3. The expansion of operational flexibility by raising the retrenchment threshold to 300 workers. 4. The mandate for aggregators to contribute 1% to 2% of their turnover into a social security fund. And 5. The ongoing implementation delays caused by the concurrent list framework. Which brings us to the ultimate question. As we approach the late 2025 rollout, we really have to ask, will these 4 codes truly formalize India's vast, unorganized economy and propel its global competitiveness? Or, by increasing flexibility in fixed-term contracts, will they simply formalize job insecurity? The architecture is built, guys, but the true impact depends entirely on uniform implementation and enforcement. Keep an eye on how the states adapt these rules, because that is exactly where the future of this workforce will be decided. Thanks so much for joining me on this deep dive explainer. Keep learning, and I'll see you next time.